I will talk on the relevance of the discourse of judicial activism versus judicial restraint. One of the most common distinctions in both public and professional discourse in the field of law in the United States, in Israel, and in many other countries is between judicial activism and judicial restraint. This distinction is common mainly in constitutional law and in other fields of public law, such as administrative law. However, sometimes this distinction is used also in the context of private law. Despite the popularity of the distinction, which is mentioned in many thousands of books and law reviews articles, as well as in a lot of court decisions, it is based on extremely vague terms and concepts which lack clear definitions. In the words of Kinen Kmick in an article which was published in 2004 in the California Law Review, as the term judicial activism has become more commonplace, its meaning has become increasingly unclear. This is so because judicial activism is defined in a number of disparate, even contradictory ways. Scholars and judges recognize this problem, yet persist in speaking about the concept without defining it. People are using the same language to convey very different concepts. These were the words of Kmick. Despite this difficulty, it seems that in general, speaking on judicial activism or restraint assumes that the judiciary has a key role in shaping legal policy. This assumption is implicit not only in approaches which favor judicial activism, but also in approaches which judicial activism and support judicial restraint. The question is whether it is desirable that the judiciary would be active in using its powers. The question arises in several aspects, including striking down policies of other branches, departure from the court's own precedents, departures of the intent of the lawmakers, and the judicial review not only of procedural matters, but also of substantive issues. In this context, Justice Aaron Barak wrote, "Both judicial activism and judicial self-restraint are relevant concepts only when there is judicial discretion. A judge which declares the existing law and does not create a new law is not an activist, neither he is a self-restrained judge. Similarly, a judge must act within the law, and no self-restraint or activism do not justify a violation of the law by the judge. Indeed, only when there is an option to choose among several legal options, it is possible to examine whether the choice indicates activism or restraint." This was the words of Justice Barak. From this statement, it seems that the debate between judicial activism and restraint is not relevant in regards to judicial decisions, activist or restrained, which are not within the law. However, even though Justice Barak argues that illegal judicial decision is out of disputes regarding judicial policy, in practice, the meaning of his words is that one has to deny judicial activism or restraint resulting in violations of the law. In this presentation, my argument, which I believe that Justice Barak would agree to partially, is that, as a rule, courts have to distinguish between substantive law and judicial review matters, avoid as much as possible considerations relating to judicial review, and rely on the interpretation of substantive law. Although I will focus on demonstrating this argument by Israeli law, its jurisprudential nature is quite universal. The Israeli Supreme Court's decisions indicate that judicial review is not only an instrument for the resolving disputes with regard to the question of whether a statute enacted by the Knesset, the Israeli parliament, or the governmental decisions are consistent with the provisions of the basic laws. These are, in a way, the Israeli constitution or other relevant laws. Rather, the settling of the differences is justified on the basis of considerations, some which are of an interinstitutional nature, which concern the relationship between the non-elected judicial branch and the elected legislative branch. The emphasis on the role of the judicial branch is not only in context of reservations against that role. At times, the role of the Supreme Court is presented in positive contexts of special contribution to the protection of human rights. In Chief Justice Barak's words, the degree of society's sensitivity to the preservation of individual liberty is reflected in the extent of judicial review of a decision by an administrative authority which violates a right. Indeed, the preservation of individual liberty is too dear for us to leave it explicitly in the hands of the administrative authorities. I know that judicial supervision does not always ensure the protection of human rights. Nonetheless, I am convinced that the absence of judicial supervision in the end leads to violation of human rights. And I can say in many cases, the court does not distinguish between the question of the interpretation of material constitutional law and the court's own considerations in exercising judicial review. Thus, for example, Chief Justice Barak ruled as follows. The court will show judicial restraint and will not replace the discretion of the legislature with the discretion of the judge. At the same time, judicial restraint is not equivalent to judicial stagnation. Judicial moderation must not give rise to judicial paralysis. When the legislature violates a human right which is anchored in the basic laws, and the violation exceeds the extent required, there is no other choice than to adopt a clear judicial position. Just as we are not free to repeal a statute simply because we would not have enacted it, had we been members of the legislative branch, we are also not at liberty to refrain from replacing a statute merely because the legislature saw fit to enact it. We, the judges, have been assigned the constitutional role of preserving the criteria for the constitutionality of the statute which are set forth in the basic laws and preventing any transgression beyond the boundaries. And indeed, the court demonstrates theoretical ambivalence with regard to its role. If the tool is to preserve the criteria for the constitutionality of a statute which are set forth in the basic laws and to prevent any transgression beyond the boundaries, why does it sentence itself to restraint and moderation? What is the relationship between the policy of judicial moderation and the role of the court, which requires it to hand down decisions according to the rules set forth in the basic laws? The answer to this question, as the court sees it, may apparently be found in the following sentences by the current Chief Justice, Israeli Chief Justice Dorit Beinish. And she wrote, "The court should carry out the role given to it in our constitutional system and examine the constitutionality of the legislation enacted by the legislative branch. This examination should be made by striking a delicate balance between the principles of majority rule and the separation of powers on the one hand, and the protection of human rights and the basic values underlying the system of government in Israel on the other." These were the words of Chief Justice Beinish. And the meaning of this statement of the court takes no interest in the balance between human rights and the purposes of the violation thereto, as is acquired by the basic laws on human rights, which state that there shall be no violation of rights except by a statute which fitting the values of the State of Israel, enacted for a proper purpose, and to an extent no greater than is required. In addition, the court also refers to the balance between the need to protect human rights and the remaining basic material values of Israeli society on one hand, and on the other, the principles which concern the relationship between the non-elected judicial branch, that is, the principles of majority rule and the separation of powers. That is likely to imply that constitutional judicial review is operated according to principles which are not identical to those which apply to the Knesset as the legislative branch. Whereas the Knesset, when operating as the legislature, is required to uphold the basic laws, and only those laws, the courts, while taking into account the material constitutional law set forth in the basic laws, also take into consideration principles which are external to the material constitutional rules set forth in the basic laws. Nonetheless, in certain case law, there is a tendency to combine, at least rhetorically, considerations of material law with considerations of separation of powers and majority rule, which are external to them. Thus, for example, Justice Barak wrote, in cases where a range of means exists, it is necessary to recognize the maneuvering power and the sphere of discretion of the legislatures. The determination of social policy belongs to the legislatures, and they come, punishment thereof belongs to the government, to both of which room for legislative maneuvering has been given. But these statements, which seem to reflect interpretation of the basic laws as providing the elected branches with room for legislative maneuvering, are justified by addressing the relationship between the roles of the legislative branch and those of the judicial branch, while ascertaining the need for special care and restraint on the part of the court. Notwithstanding the importance of judicial review, Constitution and basic laws, like most other legal rules, are not directed to the courts. Rather, they are primarily redirected at the elected branches of government and at individuals, the citizens and residents of the state. The unique aspect of the Israeli basic laws as legal rules which are superior to other laws lies in the fact that they are also primarily directed at the legislature. They prevent the Knesset from enacting certain statutes or require it to enact others. As in the United States and Canada, the power to engage in judicial review in Israel is derived from the very jurisdiction of the court, which is generally a mandatory jurisdiction to decide legal disputes. One can argue that all these assertions are formal and technical, and that in fact both the basic laws and the theory regarding their supremacy over other laws are intended to enable judicial review of parliamentary statutes. Thus, judicial review was not intended to give effect to the basic laws. Rather, the basic laws were intended to enable judicial review. Nonetheless, for the time being, the principal practical impact of the basic laws, which embody the Israeli constitutional revolution, that is the two basic laws which relate to human rights, has been on Knesset legislation and not on judgments which have exercised judicial review of the constitutionality of statutes. Since the outbreak of the constitutional revolution, the Supreme Court has only invalidated 6 or 7 statutory provisions. In contrast, the constitutionality of all legislative bills has been examined by the legal advisors to the Knesset and government and by the members of the Knesset themselves. Bills which raise doubt as to the compliance with constitutional requirements are normally cancelled, delayed, or redrafted. Moreover, certainly as a result of the influence of the basic laws, the Knesset has enacted a series of new statutes in relation to which an effect has been made to respect human rights. These new laws replace previous laws which disproportionately violated human rights. In cases where the court invalidated Knesset statutes by virtue of the basic laws, the Knesset amended the statutes in accordance with the guidance given in the judgment. At the same time, it is preferable to focus on the substance of the constitutional constraints on the legislature and the executive, not only from a practical point of view, but also in terms of the strategy of determining the content and the interpretation of the basic laws and in the future of the Israeli constitution. Systematic discrepancies between judicial review considerations and the principles set forth in the basic laws are likely to give rise to replacement of the constitutional rules by rules of judicial review, or the obscuring of the distinction between the constitutional rules and the policy of judicial review. Thus, the common approach is likely to lead to a lack of clarity with regard to the nature of the limitations and duties which are imposed upon the legislative and executive branches. As a matter of a norm, the starting point should be that these branches, which operate according to legal advice, are interested in operating according to law in a manner reconcilable with the constitutional rules which apply to them. And in any event, it is proper for the court to exercise the power of judicial review by adopting an interpretation of the basic laws which focuses on the nature of the rules which apply to the elected branches and not on the nature of the rules which apply to the court itself. And in this way, it will enable the other branches, provided that they desire to do so, to operate according to law, according to the constitutional laws. It is quite possible, for example, that the correct interpretation of the Israeli Basic Laws will allow the elected branches a broader range of discretion in matters which concern economic or security-related policy than in other matters. Accordingly, it is quite possible that the range of discretion which is given to the legislature and the executive in matters related to human rights is more restricted than the range of discretion given to them in other matters. At the same time, the interpretation of the basic laws should not be derived from the considerations which concern the judiciary or its relationship with the other branches. Even if, in the opinion of the court, there is a justification in certain cases for not basing its decisions exclusively on the interpretation of the basic laws and the application to the fact of the case before it, and even if it is appropriate for the court to take constraints of the judicial branch into account as well, it must make a clear separation between the various aspects in order to enable the elected branches and their legal advisors to know which constitutional limitations and duties are incumbent upon those branches. Mixing considerations of constitutional interpretation, which considerations which concern the policy of judicial review, is likely to give rise to errors in the court's decisions. These errors, in turn, are likely to have an undesirable impact on the methods according to which the principle of binding precedent behaves. Thus, judges who hold before their eyes interinstitutional considerations, which are likely to justify the restraint of judicial review in the context of certain rights, are likely to formulate the rulings in such a way as to imply that the weight of that right is materially less. Moreover, the judges might not carry out their examinations with the requisite degree of stringency if there really is sufficient justification for the outcome of the decisions not to comply with material constitutional law, but rather to be biased by considerations or constraints of the judicial branch itself. Ironically, it is precisely the stressing of considerations which concern judicial review policies without distinguishing between these considerations and material and constitutional law, not to mention the replacement of material and constitutional law by policy of judicial review, which can prejudice the public status of the judicial branch. The public trust in the non-elected judicial branch and the public belief that the judiciary operates according to professional legal considerations and not according to the judge's own political agenda may be prejudiced precisely by a declared practice of underestimating the weight or even ignoring the existence of material constitutional law. To conclude, as a rule, the courts should make decisions based on constitutional law considerations and not on institutional considerations relating to the judiciary itself and to its relations with other governmental branches. Judicial decisions should be evaluated according to the substantive law correctness and not according to the activist or self-restrained nature. If by the correct interpretation of the law other governmental branch acted unconstitutionally or illegally, the court should give the appropriate remedy. If the governmental branch acted constitutionally valid, the court should reject the petition against it. Judicial review is intended to interpret and enforce the substantive law. There should be no significant gap between the substantive law rules and the judicial review policies. This approach is not related to the disputes on judicial discretion. Even if the courts have wide discretion when they decide in legal matters generally and in constitutional questions in particular, they should use this discretion as a rule in light of substantive constitutional and legal considerations relating to the subject matter hereof, and not in light of institutional considerations of the judiciary and its relationship with the other branches of government. Decisions of the courts should therefore be written and in light of substantive principles. The question of whether they express judicial activism or restraint is not relevant. Thank you.